Hello, good people, and welcome to the Higher Living Podcast. My goodness, do we have a treat for you today? Today, we've got in studio with us Ivan Israelstam. Ivan has got many, many talents, apart from being the CEO of Labor Law Management Consultancy, which is a leading firm that specializes in labor law and helping employees and employers navigate the spaghetti string of labor law to make sense of it and to implement it in a manner that is correct. Ivan is also has an illustrious career in the labor space, as well as other fields. He's also been a commissioner of the CCMA and many other things. So without further ado, Ivan, welcome to the Higher Living Podcast. How are you doing this afternoon?
Thank you very much, Sean. I'm doing well. I'm very glad to be with you.
Thanks, and thanks for making the time. I know how busy you are. And I think it's actually so appropriate for us to speak to somebody like you at this time of the year. Typically as we get to the tail end of the year, the November, December areas, people are pondering, reflecting firstly on the years that they've had in their employment, their space of employment. And then they're also pondering about the future, what the future might hold. And I think, there's this underlying blanket of legislation called labor law that not everyone fully understands, even that of when you leave a job or you join a new job, or as an employer where you leave or hiring new people. There's very much this blanket that needs to be well understood. So I think it's a good time of the year that we're having this conversation with you. Do you find that your workload typically rises at this time of the year?
It does sometimes, and it certainly has this year. Up until a few years ago, work used to start tailing off towards the end of November because people were thinking Christmas.
Yeah.
But then something happened. I don't know if it was COVID or the economic circumstances, but I'd say about 4 or 5 years ago, this time of year started to become much busier. And this year is certainly a typical example of that.
Okay, well, that's interesting. But I mean, before we delve into the world of labor law management consulting, can you give us a bit of an appreciation of who Ivan Israelstam is, a bit of your background and how your career has led to the point of you being the CEO of your own business, being an entrepreneur, and helping organizations and people navigate complex labor law?
Yeah, I'd be happy to do that. Just to start off with me as a person, I am a South African, lived in Joburg most of my life. I'm fortunate enough to have a wonderful wife to whom I've been married for many years and 2 grown-up children. I started off my career in accounting, and I very quickly realized I was not interested in figures, I was interested in people. And I then studied and practiced as a social worker for 2 years. And because the salary couldn't support a family that we wanted to start, that's when I moved into the HRIR field. So for most of my career, I've been in HR, industrial relations, and then about the last 30 years in labor law and industrial relations. So that's a kind of high-level background. For part of that time, I was in labor relations management in-house, but then in the mid-90s went into consulting, started off working for a consulting company, and then in 2003 I began my own consultancy, which is Labor Law Management Consulting, and we will have our 20th birthday, if one could call it that, or anniversary, in March next year, which we're very much looking forward to.
Wow, 20 years, 2 decades. And I guess like any business does, that 20 years must have a story of its own, morphing and lefts and rights and ups and downs and all sorts of different tales that have morphed the business to where it is today.
Very much so. It's been hard work, but very enjoyable indeed. I mean, after 3 attempts, I finally really did find my niche and my place in working life. I really have always loved what I do, especially the training side. And because of that, I'm actually in the process of converting one of the books that I wrote into a video.
Okay.
So that is the most exciting thing that is happening at the moment. But my own focus in this field is to help employers to walk the labor law tightrope. Because what's happening is employers need to run efficient businesses, but they also have to comply with the labor laws, which are very restrictive and sometimes not very clear. So I always see employers walking on a tightrope, where if they focus on one of those priorities too much, they fall off the other side, and vice versa. And my role is to convert that very shaky tightrope into a stairway to success.
Well, that's a very nice way to put it. Yeah, that's a very nice way to put it. You know, we've had we're going on 20 episodes of this podcast, and I must say, in every single episode, I stand to be corrected, but in almost every episode, or I actually think in every episode, the story of success begins the same way, where people start their careers in a field where they believe that they should be or want to be. And very quickly they realize that that's not what they do want to do. And then there's a back and a forth and an up and a down. And then they eventually, life brings them into a space where they find their passion and they find their call to action in terms of you know, what they really, their purposes and what they really want to do on this world, you know.
Well,
And
sure.
I think
I find that extremely interesting, because I kind of thought that this was an unusual thing, but you're actually saying it's fairly common, which is very interesting.
no, it's almost, and you know, I've been so blessed on the show to have some really successful, really interesting people on my show, and almost every single one of them, like I say, to be corrected, I think every single one started the same way, where there is this period of almost earning and exploring, and then eventually finding the home of passion and calling and purpose. And it
Yes.
is just very interesting for me to know that. And the point I get to there is that, and I'm talking about it from the perspective of an employee now, is that sometimes people should step outside their comfort zones when they're not happy in the type of work that they're doing, or it's not fulfilling them, or it's not enabling the lifestyle that they want. Step out of that and try something different. Take the risk and try something instead of just accepting what you have in a state of comfort.
Well, from my point of view, I couldn't agree more. And I'm wondering whether it's possible that people who've got a varied background might have the advantage of that background making them a better qualified person for life, because the accounting that I learned when I was in accounting and the social work skills I learned in that field, I've used a great deal in running my business.
Sure.
You know, the social work side has made me very much more sensitive to the needs of the people who I'm helping. It also gave me skills on how you actually help people in a constructive way that strengthens them rather than making them dependent.
Yeah.
And of course, the accounting side enables me to run my business as a business.
Yeah, absolutely. A successful business, by definition, is profitable, you know, and for that, you need good financial management skills. Absolutely. Ivan, tell me, helping these employers walk the tightrope is something that, you know, sometimes we feel as a smaller businesses, sometimes the guys feel that they're in the startup phase. They've only got one or two employees. Some of it is quite unstructured. Employment contracts are quite unstructured. And then you get, as the business grows, you get these, you know, your team grows, and so you put in procedures, policies, and the requisite employment contracts, and then until you get to a point where you actually formalize everything. My question to you is, you know, when you are in the startup phase, which many people are, and you just have a few people working for you and that sort of thing, how important is it to focus on labor law? Because often the entire focus is on revenue generation and service delivery.
The unfortunate thing is that, to a very large extent, the labor law is not different for smaller employers, for newer or smaller employers. It's the same. There are a few very small and insignificant dispensations for smaller businesses, but they really are not very significant. So a small employer who intentionally or unintentionally fires somebody unfairly, for example, is going to face the same wrath of the CCMA as the bigger employer. The only difference is that bigger employers have got a lot of money to throw at it, and the smaller employers haven't. And this is unfortunate because smaller employers have less resources, they have less time, they have less money, they have less people to deal with this kind of problem. They're trying to survive and trying to make the business work. And that has a very, very severe spin-off for the economy because 90% of our economy is small businesses.
Absolutely.
And if small businesses are constrained and enchained by these very, very difficult and numerous labor laws, they can't grow. And if they can't grow, they can't employ people. And our own government keeps saying the future of employment and increasing employment and taking away our bad unemployment figures is small business. Yet the labor law makes a nonsense of that principle.
Yeah. And I mean, the reality of the situation is that even if you, as a small business owner, do not have formal procedures and employment contracts and stuff in place, but you are in fact employing people by definition, there is an underlying invisible blanket of labor law that you need to comply with.
Yes, and sooner or later, the small employer is going to employ somebody who knows more about the labor law than the employer does, and is one of those troublemaking types who's going to abuse that.
Yeah.
So one way or another, a small employer needs to gain enough knowledge about labor law in order to understand that they know very little and that they need to have somebody, at arm's length or, just a small distance away who they can say, look, I've got this problem. Before I do anything against this employee, please tell me, how the law is going to impact.
Absolutely.
That's not necessarily very expensive, but it's the very least that the small employer needs to do.
It's true. It's true. I mean, a lot of your resources are online. I mean, I've seen a lot of your templates and things and articles on various labor-related topics online. So the resources are out there. It's just about making sure that one understands them. Now, you mentioned earlier this lovely governance body, if I can call it that, called the CCMA. What is the CCMA?
So the formal name for the CCMA and similar bodies is a labor tribunal. That's what the law calls it.
Mm.
So it's a statutory body which is falling under and funded by our Department of so-called Employment and Labor.
Mm.
I call them the Department of Unemployment and Labor. But it falls directly under there. And its job is to try to make labor peace at the macro level, between big employers and their unions at that level, but also between individual employer and employees. So it's there to try to resolve disputes quickly and simply rather than disputes having to be dragged out for years. And in an expensive and complex way. So the CCMA was designed to replace the old industrial court, because the old industrial court that existed up until 1996 required a lot of time, money, and procedures to be followed. The CCMA has tried to simplify that to make it a lot easier for unfairly treated employees to get their matters resolved.
And does the CCMA actually have teeth? I mean, can they actually impose organizations to do certain things?
Yes, to a large extent. The second step of the CCMA, if peacemaking has failed, is for an arbitrator who's a junior judge, it's like a magistrate, to arbitrate the matter and to decide who is right and who's wrong. And if the employee has been unfairly dismissed, for example, to force the employer to pay the employee compensation, for example. Or the award could be reinstatement.
Okay. Yeah, and I mean, and this topic of unfair dismissal and all of that, we'll get to it in a few minutes' time. But just to come back to the CCMA, you spent how much time at the CCMA as a commissioner?
You mean when I was a commissioner?
Yeah. When you were a commissioner at the CCMA, how long were you a commissioner for?
I was a part-time commissioner for 4 years.
Mm-hmm.
So in the first year, I was there a lot because that was the first year of the CCMA's existence.
Okay.
But as the years went on, they needed me a bit less, and I became very much more busy in my consultancy. So by the fourth year, there were hardly any cases for me.
And did you see any, while at the CCMA, did you see any trends that you observed as these are the sort of like the key things that employers and employees are facing? This is where the main contentious issues arise. Is there any way any sort of trends that you saw there?
I suppose, I mean, I haven't really thought about it, but I suppose there are quite a few trends. Mm-hmm. The one that was there and that still exists is that because the CCMA is free, and it's very easy for employees to go through the processes of lodging their cases and even presenting their cases. There are a great many employees who go there and take a chance. That has always been the case. It's just so quick and easy and cheap to do that even an employee who knows he's 100% in the wrong very often is going to go there. And it's one of the things that makes the life of employers difficult. And one of the things that keeps the CCMA very much busier than it really should be. And then the other trend on the other side is that there are two types of employers. There are those that really are decent employers that do their best to treat employees fairly. And that's about maybe half employers. And then the other half are those that make the need for the CCMA a real one.
Yeah. And I mean, the CCMA deals with any sort of labor conflict. Is that from a level of your domestic worker right up to a director of a company or that sort of thing?
Yes.
It spans that entire spectrum, right?
That's right. And that is because the law is structured that way. Okay.
And when you eventually stopped serving the CCMA, it was just to focus on the fact that your own business was growing quite substantially, and you needed to focus on that.
That's right.
In your role as a part-time commissioner, was it difficult at some points to actually get parties to agree amicably? Because I can only imagine that those type of conversations are quite emotional.
Yes. I can only speak for myself. I did not find it terribly difficult.
Okay.
You have to remember that I stopped being a commissioner about 22 years ago.
Yeah, sure.
But I cannot actually remember one case where if I was conciliating, when I was in the peacemaker role, that I wasn't able to enable the parties to make peace. That might have been partly due to my own personal skill and background, but it's also due to the system that the CCMA has, and the excellent training that the CCMA gave me as a conciliator or peacemaker.
Okay, yeah, because there's a number of stages that one goes through at the CCMA before you get to arbitration. Do you want to just give us a quick overview of that?
Look, the employee lodges the dispute, and then the CCMA sets down the first phase, or the first step, which is called conciliation, and conciliation is another word for peacemaking. Some people call it mediation.
Okay.
Yeah, and that is where the peacemaker, well-trained peacemaker, helps the parties to reach their own agreement. And if they do agree, then the conciliator codifies that in a settlement agreement, which is then legally binding on both parties.
Okay.
And the CCMA settles about 60% of cases in that way.
And I can imagine it is a vast number of cases that they come through those doors.
Yes, many, many thousands. I think I saw a statistic that the CCMA receives about 140,000 cases a year.
Sure.
That's nationally, of course.
Yeah, of course.
Yeah, if that doesn't succeed in settling the matter, then the CCMA will set down the arbitration. And that is very different to conciliation. It's a court case. The parties come with their witnesses, their documents, their videos, their evidence. They present it. The arbitrator is the judge. The arbitrator then goes away with all the evidence and then decides, was this fair or wasn't it? And then if it was unfair, comes up with the remedy.
Okay.
It's a very, very good system.
It does sound that way. It does sound like, from what you're saying, people are well trained. It's quite slick. People are very competent. But I must be honest with you. I had someone ask me this question the other day, and it might be a bit tongue in cheek. The question was, who owns the CCMA? And the context of the question was posed to me because the person felt like the CCMA could be swayed either way, depending on the might, the financial might of the company or the person or the employee.
Yeah. So in terms of your first comment, I don't think anybody owns the CCMA. Employees own the right to take employers to the CCMA. That's about as close as we can use the word ownership.
Oh, okay.
It is true that any arbitrator, any judge at any level, and we have many levels of our courts, all the way up to the Constitutional Court, can be susceptible to being influenced by either party, either the employer or the employee.
Sure.
And I've come across a couple of cases where that's happened at the CCMA. But in my experience, it is the exception. But certainly, I know it happens.
Sure.
And it will happen at any court in any country. And I don't have a sense that it's happening here more than anywhere else. But that doesn't make it right, of course.
No, of course, but that's very positive feedback, and I'm very glad that you've given us some assurance around the rigor that goes into this body, because it is a very important aspect of our labor law system. The next piece that I wanted to chat to you about was, you spend a lot of your time at the moment in CCMA representing your clients.
Not much.
Really?
Yeah, not much. And I'll tell you why. My clients have learned, either through training or through consulting, the right way to treat employees. That's the first thing. So the need for them to be taken to the CCMA is substantially reduced by that. I'm somebody who very strongly believes that prevention is better than cure. It's not good for anybody to allow a matter to get to the stage where it has to go to the CCMA. Secondly, if the matter goes to the CCMA, and if my client, the employer, is in the wrong, I tell them they're in the wrong, and they settle the matter quick for CCMA or at CCMA, at the conciliation stage. And you don't really need a representative at the conciliation stage. So clients sometimes take me there at the conciliation stage, but most of the time I prepare them and then they go and they settle it if they are in the wrong. And because I manage my clients in that way, there's seldom a need to go to arbitration. So it happens. I'm on my way to arbitration in a few days' time, but it's not a common thing for me.
Okay.
Thank heavens, because to me, as I say, I prefer prevention. I don't like firefighting.
And do you find that most of your clients contact you when there's the issue or when the fire is blazing and they need help to put the fire out?
I'll divide that into two answers.
Right.
My established clients always contact me before the pawpaw hits the fan, if I can put it
Right.
that way.
Okay.
And that is why they so seldom land up at CCMA. Very simple.
Mm.
But I get lots of new clients who approach me when the pawpaw has already hit the fan. I can't tell you how many clients on both sides, employers and employees, say, "Hi, Ivan, I hope you can help me. My CCMA case is tomorrow."
You kidding me?
Yeah, it's
Really?
laughable. So they've known about it for 3 or 4 weeks, but they've kind of shoved it under the carpet until the last minute.
Sure.
Makes life very exciting.
Yeah, I can imagine. And they just think that you are going to be available, like you're just waiting there for their phone call to come through so you can go and appear at their CCMA and help them with their CCMA situation. Sure.
Yes, but in any case, even if I would be available the next day, I need 1 or 2 weeks to prepare.
Yeah, absolutely. I can only imagine, and having been through this process as well, not CCMA, but going through the labor process it is the nitty gritty. The devil lies in the detail, as they say, and it is
Yes.
so applicable for this specific topic.
True, 100% true. There's so much detail in terms of labor law. You can't imagine how much detail there is. And it's mainly because the laws are so complicated, and many of those complicated laws aren't even clear.
Yeah, open to interpretation.
Hugely.
So if they're open to interpretation, how does a commissioner at the CCMA manage to decipher the correct meaning and be able to pass a ruling? I mean, how, is that part of the training, I guess?
Well, training is very important. Just to deviate very slightly, in criminal law, 99% of the law is in the Criminal Procedures Act. So you've either broken the law or you haven't.
Yeah.
In labor law, it's completely different. Firstly, the law is very complicated. Secondly, it's very unclear. And thirdly, labor law is based on the principle of fairness. It's heavily based on the principle of fairness, to the extent that the arbitrator has to decide, was the dismissal procedurally or substantially unfair? And the concept of fairness and unfairness have not been defined. So each commissioner makes the decision truly based on their own sense of what is fair.
Sure. So by virtue of that, could it mean that sometimes the outcome of your CCMA case or situation is determined by the commissioner that you get?
In every single case, that is true.
Sure.
Because every single individual has got either a big or small different opinion of what fair is.
Yeah.
The concept of fairness is 100% subjective.
Absolutely.
So we were given guidelines, in terms of when we were trained, but that's all they could give us is guidelines. But
Sure.
there's so much room for movement within those guidelines. If one spends time looking at decisions in the Labour Court and Labour Appeal Court, whether one party or another has taken the CCMA to court and on review, you will see exactly what I'm saying, because there have been so very many such cases.
Sure. And from bringing it back to from a business perspective now. So if you're an employer, you work in the HR department of a company, then you're tasked at looking at labor law. I mean, you would need to look at the acts and then almost determine your own scale of what's fairness? Or is that why it's important to have a consultant that you can use that would guide you in terms of the guidelines that the CCMA might or might not use?
Yeah, so that's a very important question. The employer needs to educate itself. And the different things you've mentioned are all sources of that learning.
I guess not knowing the law is no excuse for when you get to the CCMA, you can't say to the CCMA, I didn't know.
Can't. Ignorance of the law is no excuse.
Yes.
So that is why I write so much. It's why I try and do as much training as I can, webinars or in-house training. It's simply because employers and employees out there might have some vague sense of South Africa's labour law. But the huge detail, they really don't have a clue without reading up, attending seminars, because if you don't do it that way, then you learn expensively by making a mistake and then being taken to the CCMA.
Mm.
And even the most honest, decent employer has got that risk.
Yeah. And I mean, so what should one do? What is the best practice? Is it good to sort of have if you're in a state and you're a small business, and if you're in a state where you are employing people, whether it be perm or temp or whatever the case may be, is it a good thing to have an assessment done on your business as step one, just to see where you're at in terms of identifying the gaps?
Yes, and it's more than an assessment.
Yeah.
If you can afford it, and that's the problem for new employers, affordability. But if you can afford it, in addition to having a really good, reputable, well-qualified labor law advisor on your side, if you can afford it, you need to have your policies, employment contracts, all put into place, because those are the structure, the labor law structure that you would need to lean on.
Yeah. I mean, there's even but we forget that there's even an underpinning labor law that governs, this labor law that governs our domestic workers and our gardeners and all of these sort of things.
Yes. And that is the same labor law that governs businesses.
Exactly. And some of us take it for granted that, we can sort of manage our personal employees that are servicing our home in a slightly looser fashion. And when I say that, I mean no pay slips, no UIF contributions, those things still need to be done.
Yeah, no employment contract. There's a very, very prevalent myth, especially amongst domestic employers. I'm going to be clever. I'm not going to give my employee an employment contract. That will make him or her a casual, and then I can do what I like. That is such a terribly wrong and dangerous myth, but it's very, very rife. Employers don't understand that the employment contract protects the employer much more than it protects the employee, because the employee is protected by the law. The employer is not protected by the law. So the employer needs to build systems such as contracts, knowledge, policies to protect itself.
Sure. Now that is an interesting perspective that I think many people out there, including myself, didn't realize.
Yeah. It's a nightmare if you don't really know what the odds are, and how the odds are very much against employers.
Yeah, because sometimes you hear people going through these struggles, and they say, look, it just feels like the labor law just benefits the employees. And what you are conveying to us now, I suggest that it does. It's actually structured that way.
There's no doubt about it at all. If we look at it historically, the old Labour Relations Act of 1956 that died in 1996 was thrown out and completely replaced when South Africa's new government came in. And one of its main objects was to protect employees who had been previously very, very badly exploited under the old apartheid regime. Sure. So the labor legislation we have now is a direct reaction to the terrible exploitation that happened in the previous 40 years.
Oh, it makes sense. It makes sense.
Very much so.
Right.
But the pendulum has unfortunately swung too far to the other side. And the casualty are people who are unemployed. They can't get jobs because employers don't want to employ people under the current regime of labor laws.
Yeah, it's almost like you're trying to grow your GDP of the country through creating employment, but you also, your stick is so big that employers are scared of the stick, so it undoes everything that you try to do from an employment upliftment perspective.
That's right. So employers use technology instead of people, and this is where the bogey of artificial intelligence comes in. Many employers are moving their businesses overseas, And what does that mean? It means that we are exporting jobs.
Yeah, it's true. And like you say, digitization and what we call digital workers is becoming now not digital workers anymore, digital teams. So
Yeah.
now we talk about digital workforce, which is an entire grouping of digital workers to replace human teams. You know, uh,
Absolutely.
and the tech is so advanced, and the tech doesn't take leave, and the tech doesn't go to the CCMA, and all of those sort of things. It's relatively low maintenance, and then now it makes sense why a lot of organizations are trying to move at that scale, like you say, moving operations elsewhere just to get rid of the requirements of what it takes to manage the labor side of their business.
Yeah. For example, there are a lot of great employers in countries like Botswana and Malaysia
Yeah.
because they've got much more balanced labor laws.
Mm.
They've got labor laws and they protect the employees well. But there's a balance. We had a very unfair balance in the past against employees, and now it's gone the other way.
Yeah. And do you believe there'll be a review of this at any point, or do you think that what we have is there to stay for the years to come?
The best way that I can answer that is the day that our government stops being controlled in terms of labor matters by the unions, that will be the day that the balance will start to restore.
Yeah.
While the unions are in charge, it's not going to happen.
Yeah. Yeah. And Ivan, we are running out of time, and I wanted to touch on this very briefly. We have spoken about it just a few minutes ago, briefly. The reality is that technology is being inculcated and has been inculcating for many, many years now into various industries. Do you see your business using technology? Have you considered how you can use technology in your business to service your clients, simpler, better, faster, if I can coin that famous saying?
I haven't really seen the need to do that in my business. But it doesn't mean that won't become a possibility.
Yeah.
But right now, it's the technology I use is just what everybody else uses to run their business, their computer, telephones, and so on.
Yeah. Yeah. I think, also, and I haven't come across anything at the moment online where one can there's almost a database of labor related, not even FAQs, something that's more detailed than that regarding the actual legislation and what it means, and where employers can just go in and click on something and get a template. And does anything like that exist in the market?
There's a lot of that.
Is it okay?
The problem is that if you're an employer and you have, let's say, a template for an employment contract, there are so many changes that you need to make to that standard template that it's actually dangerous to use a template.
Yeah.
You think that the template is comprehensive, but it's nowhere close to it.
Yeah. Yeah, and that's sort of where I was going to in terms of the AI piece, where you could go in and put in specifics about your company, and on the back end, this would then generate something that is quite specific to your industry. But I guess, like you say, it is such a detailed exercise, and the legislation needs to be looked at such a detailed level that it's very difficult to do that without a detailed consultation.
Exactly. You just can't standardize something that is so varied. And the bigger problem is that labor law changes literally every day. Every time a judge makes a different decision. There's no such thing as precedence in labor law because of the factors that I've raised, especially the issue of fairness and unfairness. So to try to standardize that is actually dangerous.
Yeah, look, it is very intricate, and I think that's why organizations like yours exist. So, to anyone out there that's listening, I hope you've got an appreciation for exactly what it means as an employer. The way that you need to look at protecting your entity and making sure that you're not only treating people fairly, but you have the right understanding of what fairness means in the greater legislative requirements. please reach out to Ivan, and I will share his details in the link as I always do. Mr. Israelstam, thank you so much for your time. It's been an absolute blast having you on the show. And I look forward to having you on again where we can go through things at a bit more granular level. But yeah, we really appreciate your time, and I wish you all the very best for yourself and your business.
Thanks, Sean. It's been great. And thanks for the discussion. I've enjoyed it.
Thanks, Ivan. Take care now.
You
Guys,
too.
just
Bye.
remember, if you do one thing only, and that's stay inspired. Cheers.